Hi there. This is session 4 out of a series of 5. Marina Constas from the attorneys BBM in Bedford View is going to discuss everything about levies in a sectional title scheme with us today. I think it's a very important and sometimes a touchy subject, so it's important that you as an estate agent knows exactly what the levies are for and what's paid, etc., etc. But let's leave it up to the experts to explain to us what levies are all about. Thank you.
Hi, and welcome to episode 4 of Demystifying Sectional Title. Today the topic is the L word, levies. Levies make up the lifeblood of a scheme and ensure the sustainability of the daily operational running of the scheme. I think it's really important to understand and be acutely aware of the impact that it has when 1 or 2 people don't pay their levies. But what is the levy made up of? Often you'll be asked as an estate agent, well, how much is the levy? It sounds too high. You might be asked by the seller or another owner, what do we get for our levy? We can't see anything. The trustees are doing nothing in our complex to ensure that that levy is being utilized properly. Well, I think the first thing that we need to know is that any owner has the right to go and look at the books of account and record of the scheme to see exactly where the levies go. They're able to see expenses, they're able to see the service providers, the bank accounts, they're able to see what the arrear levies are all about and who owes money. So there's really no excuse for any owner to moan and complain about the fact that they can't see where their levies go. They also are able to attend annual general meetings or special general meetings to find out what's happening in their complex. And I think, as we all know, unfortunately, most people don't make use of that really valuable opportunity. What makes up a levy? How do you come to that amount of the levy? And is every complex the same? Well, definitely not, because most complexes have really different needs. So as an estate agent, you mustn't assume that the levies are going to be the same or similar in one complex, which might be right next door to another complex. Your levies comprise of things like repairs, maintenance, renovations of common property. You need to look at things like insurance, water and electricity on common property. Also security cameras, intercom systems, all those kind of expenses fall into levies, as well as administrative fees like your auditor's fees, your managing agent's fees. Take into account things like employee salaries, importantly fall under that, and UIF also falls within the levy. Payment of any kind of administrative or governmental tax forms part of the levy. So when we talk about a levy, it's an amount that goes towards running the scheme. And how is it worked out? Do I pay the same levy as the guy next door to me? If his unit is bigger, do we pay the same? How's it worked out? Well, we go back to something we've spoken about already in earlier episodes called participation quota. And if you look at the default position, on most schemes, the levies are calculated by way of reference to the participation quota. So the bigger your unit is, the more money you're going to pay on a monthly basis for your levy. Now, participation quota can be changed. If people in a complex or the developer doesn't want to utilize participation quota because he says everything's more or less the same, or I don't feel that people should pay different amounts of levies, we're all in this together, oh yeah, your unit's bigger than my unit, doesn't matter. The developer can then at the outset record that he wants to use nominated values, equal values, or the body corporate can also do that by way of a special resolution. So if you've been charged by PQ for the last 10 years, there's nothing to stop you taking a special resolution in order to change the values from participation quota to nominated values. You could also use a combination of participation quota and nominated values by saying, well, we want to have all the normal expenses by PQ, but maybe security we don't feel should be divided up that way, and security will be worked out on a nominated value basis. That's also quite common. So that's PQ and nominated values. What else can we need to talk about? What happens if the owners don't pay their levies? If they want to sell their unit and it comes to you get the deal and the sale is on the table, very often you might hit a glitch with a body corporate who doesn't want to issue out a clearance certificate. Because at the end of the day, before the seller leaves, the body corporate needs to be 100% certain that all monies due and owing to the body corporate have been paid. And the conveyancer, in the undertaking that the conveyancer signs when the transfer is going through, he or she states that all monies due to the body corporate have been paid, or that arrangements have been made to the satisfaction of the conveyancer that all amounts have been paid. So that clearance certificate, once that clearance certificate has been given over, then the seller no longer has any liability to the body corporate, and the purchaser on transfer becomes liable to pay the levy. What happens if a levy is passed between the agreement of sale and the date of registration? That always used to be a really grey area, and I remember attorneys and conveyancers and everybody entering into tripartite agreements just to make sure of who must pay what. Well, at the end of the day, it's quite clear in law that the purchaser takes responsibility for the levy from the date that the transfer is registered, and any special levies need to be paid by the seller, even if they passed after date of signature of sale agreement, unless in the agreement it stipulates that the purchaser will take on the responsibility of the special levy, because sometimes that special levy is raised and it will really only benefit the purchaser. So there are situations, but that you'll have to see in the offer to purchase. If it's not in the offer to purchase, then the seller is responsible for that special levy. A real levy collection. What happens when people don't pay their levies? And that is becoming an increasing problem. Our firm, BBM Attorneys, deals with many buildings, and managing agents give us work where we've got to collect arrear levies on behalf of the body corporate. I feel really strongly that the body corporate has to take a zero tolerance approach to people who can't pay. Of course, in this particular situation where we have a COVID-19, there are indications and directions from the community scheme ombud that special arrangements can be made for a 3-month levy deferment, sort of levy holiday where levies are deferred, but their acknowledgements of debt should be signed to cover the time period and to make sure that the body corporate then is not out of pocket. I know many bodies corporate have approached me to say, well, can't we just reduce levies across the board? Well, the only way that you can do that is by way of an ordinary resolution of all the owners who decide, and it's something that we discourage. We don't think that that's the way to go. You should actually look at each person, each owner, on an ad hoc basis and have proof that that person can't pay their levies. Because before the virus hit, there were many people who were in arrears with their levies. And then you get a situation where every Tom, Dick and Harry is jumping on the bandwagon to say, well, no, I can't pay, and it's COVID, etc. There's got to be a certain level of compassion, but at the end of the day, the body corporate has got expenses to pay. And you can't underestimate that it would really take that complex completely backwards if you didn't receive that money. So what can you do about people who don't pay their levies? Well, there are a couple of routes to go, and the first one is you go through the courts. The courts are still a way to get levies, and if you want to attach the unit at the end of the day, then the court is one of the routes to go, where a summons would be issued against a defaulting party. If the person ignores the summons then and doesn't put in an intention to defend, then a default judgment is taken against that owner. And once a default judgment is taken, then the attorneys are able to get a warrant of execution issued, where movables are attached first. You've got to attach movables first. And if they're not sufficient movables to satisfy the judgment debt, then we can go what you call a Section 66 route, where we apply to the magistrates court to attach the unit to sell it. And then we go to the sheriff and obtain a sale date and sell the unit. So if an owner doesn't pay their levies, then there is certainly an opportunity to be able to attach and sell that unit. And that's really where many bodies corporate experience quite a few delays, because it probably takes about 6 to 8 months for that process from summons right until a person has their unit sold. The other way that you can proceed is certainly to approach the ombud, and the ombud, many cases are resolved at mediation level, because often somebody is not paying their levy due to some obscure reason, where maybe the trustees haven't answered questions and they're suspicious about where the money is going. Whereas if a meeting had been held face to face, that could have been resolved and taken forward. So mediation at community scheme ombud service level, which we'll talk about in episode 5, does assist. And I think many disputes have been resolved just by sitting around a table and taking cognizance of each other's problems or concerns. If a complex is really in serious financial trouble and hasn't been managing real levy payments and hasn't been keeping an eye on the business side, because remember, body corporate is a business. You have assets under your control, and that's why the trustees have got to take this responsibility so seriously, because if a building does run into trouble, then any creditor or owner or anybody with a stake or an interest in the body corporate can actually place the building under administration. So that's like, it's almost the business rescue of sectional title community schemes. That you can now approach the magistrates court. You used to only be able to approach the High Court to place a building under administration. The magistrate will appoint an administrator, and the administrator will then step into the shoes of the trustees. So the trustees have no power to make any more decisions. The administrator has those powers. And the administrator then would possibly be ordered to go back to court after 6 months to show what the administrator's done and to stipulate exactly what financial alternatives have been taken, and if they've sued for arrear levies and really taken over control of those finances. Not all buildings in financial trouble go under administration. We've had buildings in Cape Town on the Atlantic seaboard that have been placed under administration because of maladministration by trustees, where trustees just haven't been doing their job properly, funds haven't been utilized properly, and one of the owners has applied to the court, and the court has come to the rescue of that body corporate. So levies it's something that bodies corporate have to be tough on, and trustees need to be encouraged to be quite tough on levies, just to make that building valuable and withhold the value. Because as soon as a bank gets whiff of the fact that a building is in trouble, then you start having difficulty with the granting of bonds in that building. So there are a whole host of repercussions that can take place. Interestingly enough, if an owner is in arrears with levies, it also has the implication that if you go to a meeting and you want to vote on an ordinary resolution, you would be stopped from voting on an ordinary resolution if you're in arrears with your levies. You would still be able to vote on special or unanimous resolutions, but ordinary resolutions you wouldn't be allowed to vote on unless you brought your bondholder to assist you. One last thing, and a question that I get asked often, is could we put a list of all the defaulting owners up at the clubhouse so that we encourage encourage people to pay their levies. And I always say be really careful of that, because you could face a claim of defamation if you got the whole situation wrong, or if the debtor, if the guy, the owner, not even the debtor, had paid his levies, it hadn't been allocated properly, or there is a real problem with the way levies have been calculated and he didn't pay. So be very careful of that. And it's easy to be vulnerable to defamation claims, and there's really no need for that. It doesn't create harmony within a building either. That was a final thing, but there really is one final thing I need to tell you. Owners complain that bodies corporate just add fees onto their account. So they'll be in arrears with their levies, but then legal fees are added on, and penalties are added on, and the fine that they got last year gets added onto that account. In terms of the new legislation, you're not allowed to do that anymore. The only thing that can appear on the levy statement is the actual levy, or a special levy, or a charge for a service, but it's got nothing to do with penalties or anything like that. Or legal fees have got to be taxed before they get put onto an account, and bodies corporate should know that. So these are interesting little sort of tidbits that could go a long way. If you mention that to trustee, they would really respect that you knew those kind of things. So yeah, levies can't stipulate how important levy payments are, and going forward, it's going to become even more vital that owners pay their levies, and should be encouraged to do so. Thank you.
All right, now you all know a lot more about levies. Needless to say, without levies, sectional title can't last for too long, stating the obvious. So yes, I hope you've gained more knowledge, and thank you once again to Marina Constas, the co-author of the book Demystifying Sectional Title. The 5th session will follow soon, and we'll chat soon. Thank you.